back, son of a bitch. Shut the fuck up. Go on.
On March 21st, 2024, officers responded to 2 separate vehicle theft reports. Both stolen cars had active GPS trackers, and those trackers led directly to a shopping plaza. Under the Supreme Court's ruling in Illinois against Gates from 1983, probable cause is assessed using the totality of the circumstances, 2 victim reports plus real-time GPS confirmation of stolen property at a specific location. Clears that bar without question. The Fourth Amendment was satisfied before officers set foot in that parking lot. But what was inside those cars would make this far more serious than auto theft.
S12. Denison is 71 now. I did not see it pass me.
Little did the suspects know, both vehicles had tracking devices, and officers were able to track their every move. They received an alert that the stolen vehicles were in a local shopping plaza.
Don't move! Put your hands behind your back, son of a bitch. Shut the fuck up. Go on. Where's the gun? It's reaching the waistband. You fucking asshole. Fucking dickhead. 571 in custody. Here, grab this fucking bitch so I'll load this thing. Official. Stop and search. Listen, you're under arrest. I know. You got the right to remain silent. Anything you say can be used against you in court. You got the right to consult with an attorney present during questioning. And if you cannot afford one, we provide you for questioning. Anything on you? No, sir. Quit moving, bro. Fucking stand still. Sorry. Don't say I'm sorry, just don't do it. Who's over there, Caleb? We're gonna need another transport car. And my 4-runner.
What are you doing? Is that jacket back up?
Bro, shut up.
It's cold.
Suck it up.
I'm sick.
Poor guy.
Yeah, this one is on too.
Riley, got 4 all together. You gonna start organizing this? You want me to take that?
Yeah. Which stuff is that? Is that? You got Asbury's?
Here.
Okay, got one ball in the pocket.
Alright.
Is that the only one outstanding? The one?
I think I saw 4 all together. You him, Sarge? I got one on my car.
Come on, Mom.
He ain't going in by yet. Yes, sir. Fish. This is on your floorboard. Lock your car.
A second suspect was seen running out of the car. He was given the best treatment for criminals as officers politely tackled him to the ground.
You good? What do you guys need?
You give me the car. Why is he putting me in the submission? I can't go nowhere on the home. Bro.
Alright, you good?
This is how we handle this shit.
It's good.
Well, it's really not supposed to feel good, dude. I don't need y'all to.
Do we have... $757. Can you go to 3? We have 2 detained. They're in custody. 2 outstanding. We're going to need patents for this Audi. And possibly my Cruiser.
What's your name? I don't want to answer no questions.
What's that? You have to identify yourself.
I have to?
Yeah, you do.
Or what happened if I don't answer no questions?
You're not going to get out of jail till you identify yourself. They're going to hold you. The judge is going to put you on a hold no bond.
Alright, put me on hold no bond.
Alright. Yeah. The only thing is, well, no, CPD touched the firearms. They secured them. They secured the firearms to make them safe. When we were like handling
Inside the car?
Yeah.
You want me to call Brandon down there?
All right. What's your name, man?
Arshawn Thomas.
Apostrophe S-H
A-W-A.
A-W-N. Last name?
Thomas.
O-M-A-S.
Yeah.
Birthday? How old are you? 19? Or no, you'll be 19. You're 18, right? Good address for you. 321. Alright, man. You got a phone number?
216. 13.
Alright, man, listen. Arshawn already ID'd himself. It's probably in your best interest to just ID yourself before. I mean, we're just going to ask them who you are anyway, and then they're going to tell us. So, you going to give your name or no?
No, I just want y'all to hurry up and take me where I gotta go.
What's that?
I want y'all to hurry up and take me where I gotta go.
Yeah, you're going back to Westlake's jail.
Wesley?
Yep. You going to tell us who you are?
Y'all gonna take me regardless. What do I gotta tell y'all?
Because you don't get to leave jail till we know who you are.
I'm gonna tell y'all when I get to jail.
All right. If you want to play hard ass, I don't know why. We're gonna figure out who you are eventually. So I don't know why you wouldn't just tell me who you are, so we
It's
know.
not like y'all gonna let me go. Like
You're right. We're not gonna let you go. I just want to know who the you are, so I can tell my dispatcher who's in the backseat of my patrol car right now.
I already tell him he won't tell me his name.
All right.
The teenagers were taken to the local jail where they were able to make a free call to their mommy. They were charged with possession of a stolen firearm and theft of a motor vehicle. The case is currently pending, but watch how these crooks bragged and confessed about their illegal accomplishments.
He jumped in the back seat, passenger side.
This is Birch. I got 50 on the first ticket. This is Birch. You see me? You see?
I ain't gonna fake.
On the
I
daddy
think that was him too. On the niggas.
Whoever
who
was taking me with a big
I ain't gonna
ass
fake. He
shop.
had that fat ass shop dog. All the niggas. I ain't gonna fake. He had it.
Oh,
He
niggas,
had it.
that's why I
He had it. He had
He
that bitch
told
on
me he
my
was gonna
face.
shoot me 3 times.
On the
First time-
niggas. On the homies. On the homies. I got the corroborate. I don't know.
Why he stopped chasing you and started chasing me?
He had that bitch on my face. It wasn't nowhere else for me to go, dumbass.
I didn't even know who them
On the homies. He's so shitty. I ain't gonna fake. He's shitty for that. And he left me. I opened the door. He left. And then like, how the fuck did he go past that pole? I would have slipped. That's why I need to be the driver on the homies. I should have sent you in on the homies. On the homies. You know. Oh no,
I was
homies.
gonna run that way, but I see you run that way, and I see you kill. I see
You get slammed on the niggas like I ain't gonna fake. When he put that chop in my face, I ain't gonna fake. I didn't know what to say after that. He talk about no fucking move on the nigga. I did not fucking. On the dead niggas, you running with your hands. I'm still getting busy on his ass.
You see me? Fat ass pick up.
You do it.
They got my shit.
Hold on.
They got your shit. Yours in the car, but you ain't in possession of it.
Yeah, oh god, nothing. You say my phone in the car. My phone in the car still. Damn, bro. Homies. Our first time going to jail together. That's the first time every day.
It's Westlake.
Oh, the niggas. Hey, though. Y'all found my phone?
Bro, I was sleeping in the car. I don't know what the fuck.
I don't know my. How are you? I said, y'all found my phone?
Your phone? Yeah, I'm sure we got it.
Alright. I don't know my number by heart yet on the
Bro, I
guy.
was asleep. I woke up out of smack.
What am I
doing?
Oh, you asleep?
Yes.
I opened. You ain't hear me open the door?
No, I tell her, what they on? Whoa. I look up. All I hear is,
I ain't gonna fake. That was the shittiest shit.
all I
Ever.
did is hit my face on the damn niggas got loose.
Homies out and got loose on the homies.
Hey, who the man that with the chop? Who the man with the big gun?
It looked like his ass right here on the next passenger.
No, that's not him.
No, that's not him.
It's either him or
No, it's the skinny nigga on the
Mercy
next
fast as
On Nixie fast as fuck. He had that bitch on my face soon as I got
big
out.
ass gun.
On the homies, how the f you can run with that fat ass AR? He trained for this. On the homies. Hey, that nigga that slammed me though, that shit, boy, he was humping my leg on the homies.
That was him, though.
On who that was you that slammed me? Little ass on the homies.
Hey, bro, fuck that. My leg hurt in my face, bro.
Bro, f that these niggas broke my wrist.
Bro.
These niggas broke my wrist. On the homies, I can't feel my shit. My shit numbing up right now. All the niggas, I wasn't about to stay there for 2 hours. I just got it done. On the niggas, my wrist hurt. On the homies, my wrist hurt. I'm ready to go lay down on that hard ass.
I just wet my nose.
Tell them like this. They talk about what's your other homie name? Lock me to the chair. What the fuck is you talking about? What's your other homie name? Lil Dick. I hope y'all catch you.
Who they compare me to?
I don't know. Oh, they was comparing me to my old picture, the missing picture. Oh, the homies. I was like, oh no, they ain't me. Oh, homies. This looking
I'm
sugar
like, they
me.
comparing you to Whoopi Goldberg and that bitch.
Hey, on the homies though, I got a bad on 92nd real quick. Y'all can stop over there real quick. I ain't got her number on the homies. Y'all not gonna give me my phone. I just need her number real quick. I gotta call her when I get there, boy. It's gonna be a whole bunch of niggas. Homies.
That hoe got an iCloud.
Bro, on the, she gave me her text now number on the homies.
Bro, I don't know my girlfriend or my heart.
I don't know my.
636.
On it. I think I know your girl number by heart.
What is it?
It's 330-636. Some. You don't know the last 4 digits?
Westlake far as fuck, ain't it, y'all?
I'ma just call Tay.
Let's examine the constitutional framework. When officers made contact, Miranda was delivered promptly following formal arrest. The Supreme Court in Miranda against Arizona, decided in 1966, established that custodial interrogation requires advisement of 4 rights: the right to silence, that statements can be used in court, the right to an attorney, and the right to appointed counsel. All 4 elements were present in the field delivery captured on camera. Under Berkemer against McCarty from 1984, Miranda is not required during routine pre-arrest questioning. It attaches only once custody is established. Custody was clearly established here, and what the suspect said next without being asked a single question is where this case gets complicated. The vehicle search that followed the arrest rests on solid constitutional footing. Arizona against Gant, decided in 2009, permits officers to search a vehicle incident to arrest when it is reasonable to believe the vehicle contains evidence of the crime of arrest. The crime of arrest was vehicle theft. The stolen vehicle itself was evidence. Firearms recovered inside fell squarely within that authority, no warrant required. The automobile exception, established in Carroll against the United States in 1925, provides a separate and independent basis for that search, given that probable cause to believe the vehicle contained contraband was objectively present. One suspect attempted to flee. That decision added a new legal dimension to an already serious case. The physical apprehension of the fleeing suspect is evaluated under Graham against Connor, decided in 1989. Force must be judged from the perspective of a reasonable officer at the scene, not with hindsight. A suspect fleeing a confirmed stolen vehicle known to contain firearms, ignoring explicit stop commands, presents an elevated and objectively documented threat profile. The response, a physical takedown using empty hand control, falls within the accepted use of force continuum for an actively fleeing, potentially armed individual. No weapons were deployed, no secondary strikes are documented on camera. The level of force applied was proportionate to the circumstances as they existed at that moment. But the suspect's actions inside the patrol car were about to hand prosecutors something they never asked for. With no officers questioning them, the two suspects began a spontaneous conversation in the back of the patrol vehicle. They discussed the firearms, including an AR-style rifle, identified at least one unapprehended co-participant, and described the events of the arrest in detail. These statements are not covered by Miranda. The Fifth Amendment protects against compelled self-incrimination during interrogation. It does not protect voluntary statements made between co-defendants that officers overhear and record. Under the rules of evidence, party admissions are generally admissible, and a co-defendant may be called to testify about what was said. One statement in particular, referencing instructions to discharge a weapon, may implicate solicitation of assault, a charge far beyond vehicle theft. Investigators with access to the full audio would be expected to pursue that line. Both suspects were charged with possession of a stolen firearm and theft of a motor vehicle and released on $10,000 bail. The case remains pending. The primary arresting officer earns a B+. The constitutional foundation was objectively strong. GPS confirmation plus 2 victim reports exceeds the probable cause threshold under Illinois against Gates. Miranda delivery was complete and captured on camera, creating a clean evidentiary record. Throughout the identification refusal exchange, the officer remained measured, explaining the practical consequences of non-cooperation rather than escalating, that is, de-escalation done correctly. Two concerns hold the grade below an A. Miranda was delivered rapidly. With young adult suspects, a deliberate pace is preferable to minimize comprehension challenges that defense counsel will raise. Placing co-defendants in the same transport vehicle also allowed a spontaneous conversation that, while legally admissible and ultimately beneficial to prosecution, carries the tactical risk of coordinated alibi construction. Ryan Thomas, 18 years old, receives a C-. He eventually provided identification and did not physically resist. Those are the positives. But the Fifth Amendment right he initially invoked was immediately undermined by the spontaneous in-car conversation that followed. Under Burguese against Tompkins, decided in 2010, an express verbal invocation of the right to silence is legally meaningful. What happens after that invocation is entirely up to the suspect. The admissions made voluntarily without interrogation, without coercion, were detailed enough to serve as direct evidence in a felony prosecution. His co-defendant refused to identify himself at the scene, attempted to flee, and made even more extensive spontaneous admissions on camera. Every decision made after the arrest compounded their exposure without producing any legal benefit. 3 legal principles run through this case that apply well beyond this incident. First, GPS tracking data transforms a theft report into probable cause. Victims who install tracking devices give law enforcement an objectively verifiable tool that satisfies the totality of circumstances standard without relying on witness credibility alone. Second, the automobile exception and search incident to arrest doctrine together create overlapping search authority in stolen vehicle cases. A defense attorney challenging either must overcome both. That is a difficult position, and it is one these suspects will face. Third, and most consequential, the patrol vehicle is not a private space. Active bodycam recording in a law enforcement transport captures everything. Spontaneous statements between co-defendants are not protected by Miranda. They are not protected by the Fourth Amendment. They are admissible, they are on the record, and they can be the most damaging evidence in a case because they came from the defendants themselves, unprompted and uncoerced. The right to remain silent is only valuable if it is exercised completely and consistently. Partial invocation followed by voluntary disclosure is not a legal shield. It is a liability. The broader institutional lesson here concerns the chain of custody and co-defendant transport. When officers handle physical evidence, particularly firearms in a multi-suspect scenario, documented protocols for who touched what, when, and in what condition are not procedural formality. They are the difference between admissible evidence and a suppression hearing. And separating co-defendants in transport is not standard practice in every department, but it eliminates the risk of coordinated story construction and removes the evidentiary complications that come with it. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.